there was a hearing on electronic Communications Protection Act reform and cloud computing. It was done September 23, 2010 by Jerry Nadler's subcommittee, the subcommittee on Constitution of this committee. And so technically we haven't had a hearing specifically on the cloud, but this was an aspect of it. So I'll submit the record of that hearing with unanimous consent, just so it'll all be part of the record.
Without objection, the noting of the previous hearing in the Constitution Subcommittee will be duly noted. Without objection, other members' opening statements will be made a part of the record.
This was the first time this subcommittee had such a hearing on this subject.
Or any committee. Okay. That's where you went awry. But I acknowledge that technically you were probably correct.
Let's not waste any more time on that.
We'll be pleased to begin the first hearing on cloud computing of this subcommittee by hearing from our witnesses. We have a very distinguished panel of witnesses today. Each of the witnesses' written statements will be entered into the record in its entirety, so I ask that each witness summarize his testimony in 5 minutes or less. To help you stay within that time, there's a timing light on your table. When the light switches from green to yellow, you'll have 1 minute to conclude your testimony. When the light turns red, it signals that the witness's 5 minutes have expired. And as is the custom of this subcommittee, before I introduce the witnesses, I'd like them to stand and be sworn. Do you and each of you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Thank you very much, and please be seated. Our first witness is known to and a good friend of many members of the Judiciary Committee. Mr. Robert Holliman serves as the President and CEO of the Business Software Alliance. He has headed BSA since 1990, expanding their operations to more than 80 countries and launched 13 foreign offices in addition to their D.C. headquarters. Mr. Holliman has been named one of the 50 most influential people in the intellectual property world by the international magazine Managing IP. He was also named by the Washington Post as one of the key players in the U.S. government's cybersecurity efforts for his work on behalf of industry on national cybersecurity policy. Before joining BSA, Mr. Holliman served as counsel in the U.S. Senate and as an attorney with a leading law firm in Houston, Texas. He earned his Bachelor of Arts degree at Trinity University in San Antonio, Texas, and his Juris Doctor from Louisiana State University Law Center in Baton Rouge. He also completed the Executive Management Program at the Stanford Graduate School of Business. And it's my pleasure to turn to Chairman of the Committee on the Judiciary, Mr. Smith, to recognize and introduce our second witness.
Thank you again, Mr. Chairman. I'm happy to introduce Mr. Justin Freeman, Corporate Counsel of Rackspace Hosting, based in San Antonio. Rackspace, founded in 1998, has grown into a multinational company with operations spanning the globe. They provide cloud computing services and manage web-based IT systems for businesses of all sizes. Mr. Freeman is part of Rackspace's legal team and deals primarily with the rapidly expanding field of cloud computing law. He represents Rackspace in technically complex enterprise transaction agreements, leads product review and development efforts, and directs public policy matters with a focus on cloud computing, security, and privacy issues. He has an extensive technical background, including specialization in network security systems and patient care critical healthcare IT systems. Mr. Freeman received his law degree from Southern Methodist University School of Law and his undergraduate degree from the University of Texas at Austin. Pleased he is here today to talk more about this important and growing sector of our tech economy. Welcome, Mr. Freeman.
Mr. Freeman, welcome. And Mr. Chinock, welcome. Our third witness is Mr. Dan Chinock, Executive Director of the IBM Center for the Business of Government. The center connects public management research with practice, helping executives improve the effectiveness of government with practical ideas, which has included several center reports that address cloud computing. Mr. Chinock also serves as the chair of the Federal Information Security and Advisory Board, which has explored numerous issues where security and privacy intersect with cloud computing. Before joining IBM, he was a senior vice president for civilian operations and with Pragmatics. He also served in the Office of Management and Budget in the Executive Office of the President as the branch chief for information policy and technology. Mr. Chinock left the government in 2003. He received his Master of Public Policy from Harvard University John F. Kennedy School of Government and his BA from Columbia University. Our fourth witness is Mr. Daniel Castro, Senior Analyst at the Information Technology and Innovation Foundation, ITIF. Mr. Castro specializes in IT policy, including issues relating to data privacy, e-commerce, e-government, and information security and accessibility. Before joining ITIF, Mr. Castro worked as an IT analyst at the Government Accountability Office, GAO, and was a visiting scientist at the Software Engineering Institute in Pittsburgh, Pennsylvania. Mr. Castro received his BS in Foreign Service from Georgetown University and an MS in Information Security, Technology, and Management from Carnegie Mellon University. Welcome to you all, and we'll begin with Mr. Holliman.
Chairman Goodlatte, Ranking Member Watt, Chairman Smith, thanks to companies like those who are in the Business Software Alliance and sitting here at this table, America is the top player in cloud computing. But we better watch out. Other countries are doing everything they can to knock us off the block. They have seen the forecasts that we all have seen. Public IT cloud revenue, which exceeded $28 billion last year, will grow to more than $73 billion by 2015. But the big thing that's happening is the innovation enabled by the cloud. And a recent study found that cloud-driven innovation across all sectors will generate more than $1 trillion in revenue and millions of jobs in the years ahead. Because the stakes are so high, and because of U.S. cloud companies' early leadership, some countries are taking policy steps to shut us out of their markets. The stakes of this are enormous, and if we want to get things right and to continue leading in the cloud, there's an urgent need for Congress and the administration to forge an open and competitive global landscape. I'd like to cover three things today. First, the scope of the problem. Second, the mix of public policies that are needed to address it. And third, some specific things that this committee can do. The problem before us is unfolding around the world. As was indicated in my introduction, BSA has 13 foreign offices, and we've done a lot of on-the-ground work and 2 groundbreaking studies about the cloud. One is a global cloud scorecard that looks at 80% of the global ICT market and ranks the competitiveness in a host of factors that affect the U.S. and other countries and the ability of companies to succeed in the cloud. And the second is Lockout, which is a new report about a new wave of IT barriers that are being erected internationally. Our research shows that governments in many countries are doing things to carve the cloud up into country-sized pieces so that local players can dominate their own backyards without competition. For example, in the name of privacy and security, we're seeing some countries require data to be hosted inside their borders, even non-sensitive commercial information. You would have to build a local data center to do business in some of these countries, and that could put a prohibitive burden for international cloud players. Some countries are even adopting rules that would explicitly prevent the transfer of personal information from outside their borders. Now, these are bad signs for the global economy, but especially for America, since we are so heavily dependent on selling products and services overseas. It is critical for Congress and the administration to show the world a better mix of cloud policies. And we can do that by getting 3 things right. First, we need to ensure that privacy and security rules protect consumers while also encouraging robust digital commerce. Second, we need to promote a free trade agenda that ensures that data can flow across borders. And third, we need to promote innovation in the cloud the same way we promote it everywhere else. That means protecting innovators' rights when they bring new products to market, and it means stopping all forms of cybercrime and theft. This committee has an important role to play in this issue. For example, there is a myth that cloud computing puts an end to software piracy. In reality, piracy is evolving. This committee can ensure that we have tools to vigorously enforce laws against IP theft, no matter where that technology or how that technology is used. Secondly, this committee can take a lead role in reforming the Electronic Communications Privacy Act, ECPA. In the cloud era, digital files should be subject to the same laws and protections as paper files. And finally, we need to dispel myths about the Patriot Act. Foreign governments are scaring customers away from U.S. cloud services by portraying our law as unusually invasive. The fact is, every government has authority to access data to protect national security, and everyone needs to understand that. We look forward to discussing these issues with you and to working with the committee. The future of the cloud computing industry and American leadership depends on your work. Thank you.
Thank you, Mr. Holliman. Mr. Freeman, welcome.
Thank you, Mr. Chairman. On behalf of both myself and Rackspace, I'd like to express my appreciation for the time of this committee and the opportunity to provide some additional insight into the key elements of cloud computing and address some of the primary challenges that the competitiveness of American cloud providers. Congressman Smith, I appreciate your introduction of Rackspace. With our focus on fanatical support, which is a fierce commitment to a customer-oriented set of core values, Rackspace has grown rapidly and now serves more than 170,000 customers in 120 countries, including most global Fortune 100 companies. Rackspace focuses on providing the cloud infrastructure and support technologies that enable the modern economy to benefit from the cost savings that cloud computing provides. Our latest focus is OpenStack, which is an open source cloud platform jointly developed with NASA. Open cloud technologies are the forefront of the cloud technology revolution. By fostering industry standards for cloud computing, which span multiple providers, open technologies advance security and help eliminate proprietary lock-in, which would be a requirement that cloud applications be tied to a specific provider, permitting cloud users to move their applications and data from provider to provider as they see fit. While the phrase the cloud encompasses a set of technologies, services, and use cases, far too broad to go into detail here, I want to provide you with a sense of the critical elements of cloud computing. At its most basic, cloud computing is simply the use of remote computing resources, relying on the storage and processing capabilities of a remote system rather than, say, your local laptop. We've all been using the cloud in some fashion for quite a while. Whenever we store emails with a web service like Gmail or Hotmail, we're essentially ceding control of that data to the cloud. One of the most critical impacts of the cloud is that the shift to using remote, shared resources permits businesses to consume information technology in a utility or pay-for-what-you-use model. This cost-effective delivery method makes information technology resources scalable, dynamic, and flexible, in turn driving efficiency and innovation across all sectors of the economy. In order to continue promoting the resulting economic growth, it is essential we establish a supportive legal and regulatory environment which is in alignment with the critical cloud technologies. We see two major barriers to the ongoing competitiveness of American cloud providers: market access issues, which are substantially informed by privacy concerns, and the exploitation of the U.S. patent system by patent trolls. Concerns about privacy and security of data become heightened as businesses hand off their data to systems in the cloud, and they're a major barrier to the competitiveness of American cloud companies internationally. Concerns about data privacy limit the willingness of foreign companies to do business with U.S. firms and threaten to exclude American companies from competing abroad. The lack of international privacy standards is a growing source of distrust amongst regulatory agencies seeking to enforce their domestic laws and businesses struggling to ensure their compliance. There's a perception, even if unfounded, that U.S. privacy protections are insufficient to protect the data which is stored either on U.S. soil or with U.S. companies. This concern results in a reluctance by foreign companies to do business with U.S. cloud companies, and we increasingly see regulatory authorities, especially in the EU and European Economic Area, moving in the direction of denying U.S. cloud providers access to the European market. It's critical to the ongoing competitiveness of American cloud companies that we take the lead and move towards a consistent international privacy and data transfer framework, while also providing clear interpretation of U.S. law, which impact the obligations of cloud companies managing the data of foreign citizens and businesses. The second major threat to U.S. cloud providers is the exploitation of the patent system by so-called patent trolls. These are non-practicing entities which gather portfolios of patents with the sole intent of using them to extract settlements from companies unwilling to engage in expensive and protracted litigation. These patent trolls are not protecting inventors or benefiting startups. To the contrary, a recent study calculated that their predatory tactics have resulted in the direct costs in excess of $29 billion to the industry, with approximately 40% of those costs borne by small and medium businesses. Patent litigation costs routinely exceed $2 to $3 million per suit, and patent trolls seek settlement after settlement in order to artificially increase the value of a patent portfolio without any relation to its actual market value. The result is a cascading extortionist abuse of the patent system. Cloud technologies are advancements to existing information technologies and require fair and balanced patent system in order to remain innovative. Cloud and open technology standards cannot survive in this environment. It's essential that we protect the growing use of standardized cloud technologies, the benefits they bring, and allow cloud companies to reinvest in technologies, jobs, and innovation instead of revenue-draining litigation. We at Rackspace share your commitment towards creating successful legislation that enhances U.S. business competitiveness while ensuring the internet remains a free and open driver of innovation for our long-term future. Thank you for your time. We look forward to working closely with you.
Thank you, Mr. Freeman. Mr. Chinock, welcome. You may want to turn your microphone on there.
Thanks.
Pull it close.
Will do. Thank you, Chairman Goodlatte, Ranking Member Watt, Chairman Smith, and the subcommittee for the opportunity to speak today. And thank you for the introduction earlier. I'm Dan Chinock, Executive Director of the IBM Center for the Business of Government. The center helps government executives improve the effectiveness of their agencies and programs and has addressed cloud computing from a number of perspectives over the past few years. My testimony today draws on this and other experience with the growth of cloud computing. Moving to the cloud brings numerous demonstrable and positive outcomes, such as cost savings, shared resources, increased program effectiveness, energy and environmental improvements, and, as others have noted today, innovation. I will focus today on three key issues that we see cloud can best be leveraged now and in the future. First, how to implement cloud efficiently. Second, how best to address security. And third, how to leverage the cloud's global model effectively. Key for success with cloud implementation is a strategy to define how to increase efficiency, save costs, and improve performance of programs in the cloud. A small investment in upfront planning can pay large dividends in measured outcomes from any cloud migration because most entities integrate cloud into their existing legacy environments. They must make choices as to what technologies, processes, and data should migrate to the cloud over what period of time and at what cost. I would note that the federal government has already begun to realize the benefits of cloud computing. Movement to the cloud can fundamentally transform how federal agencies leverage IT, and efforts such as the OMB Cloud Strategy and GSA FedRAMP initiatives are spurring progress. Our center has produced papers that are on cloud implementation available at our website, businessofgovernment.org. With respect to security, despite perceived concerns about security risks, cloud can provide for an environment that is superior for implying many critical security measures. Centralizing data storage and governance in the cloud can actually provide better security at a lower cost than is the case with traditional computing environments. Moreover, cloud can improve certain key security practices, such as detection of threats, remediation to minimize those threats, prediction of where threats may occur next, and protection of data and devices. Regarding the global model, the benefits of cloud computing increase when providers can move computing and data power to locations that are most cost-effective, rapidly, and with no loss of service quality or security. real-time movement of computing resources points out the need to understand, as others have noted today, issues involved in cross-border data flows in the cloud. Most issues in this space are best addressed via contracts between parties who can designate jurisdiction and establish clear provisions for ownership, privacy, and security. I would like to highlight several issues that impact the cloud's global nature. These areas are the extent to which government can access data across borders, international privacy collaboration, and open standards. The extent to which government can access data across borders can be a subject of confusion among cloud providers and users. However, as has been indicated today, many nations have similar domestic data policies. A recent white paper from the law firm Hogan Lovells found that each of the 10 countries studied vests authority in the government to require a cloud service provider to disclose customer data in certain situations, and in most instances, this authority enables the government to access data physically stored outside the country's borders. And as Chairman Smith indicated in his opening remarks, this study also indicated that in a number of cases, protections from government intrusion in the U.S. were actually greater than in other countries. Regardless of jurisdiction, individuals whose data resides in the cloud will have greatest confidence if, to the extent permissible under law, they do not lose protection solely based on where their data is stored and processed. Cloud computing would also benefit from an international regime that promotes privacy and supports efficient cross-border data flows. While complete harmonization of rules is not practical or desirable, countries may be able to recognize each other's rules, including privacy safeguards. Finally, the benefits of cloud can best be achieved by reliance on open standards that promote data portability and interoperability, which are critical for successful adoption and delivery of cloud-based solutions. An open standards approach would also help to address location-based mandates. While certain practices by governments to locally source cloud computing may be understandable, governments could enhance the cloud's efficiency and cost effectiveness by avoiding location mandates and leveraging and encouraging an open global model. Chairman Goodlatte, Ranking Member Watt, Chairman Smith, the subcommittee, thank you for the opportunity, and I welcome any questions.
Thank you, Mr. Chinook. Mr. Castro, we're pleased to have your testimony.
Thank you. Chairman Goodlatte, Ranking Member Watt, Chairman Smith, and members of the subcommittee, I appreciate the opportunity.
You need to put that microphone on.
There we go. Chairman Goodlatte, Ranking Member Watt, Chairman Smith, and members of the subcommittee, I appreciate the opportunity to discuss cloud computing with you today. I would like to focus my remarks on two principles that policymakers should keep in mind with regards to cloud computing. The first principle is cloud neutrality. Cloud computing is an important trend for how organizations use information technology, but the technology itself is not so different from other forms of computing that there is a need to create cloud-specific regulations. That doesn't mean there aren't important policy issues that affect cloud computing. For example, one important issue is addressing the complex jurisdictional questions that arise from having data subjects, data owners, and service providers under different legal jurisdictions and facing conflicting regulations. Meaningfully addressing these issues may eventually require countries to develop agreements on questions of jurisdiction or standardize some data practices. Or alternatively, advances in technology that allow data policies to actually be bundled with data and ensure that these policies are enforced may help resolve some of these questions. But while these issues are important for many cloud computing companies, they are not necessarily unique to the technology. However, creating cloud-neutral policies will require some change to ensure that laws and regulations do not favor or disfavor cloud computing. One important step Congress can take in this direction is to update the laws that govern the electronic surveillance of data. The Electronic Communications Privacy Act was enacted in 1986 and has not kept pace with the advancement of technology and the growth of cloud computing. As a result, there are different levels of protection afforded to the privacy of an individual's data depending on where and for how long the data has been stored. Consensus is forming around the idea that reform is needed in this area to protect Fourth Amendment rights. The second important principle for cloud computing is for policymakers to address anti-competitive foreign practices that challenge the dominance of cloud computing service providers in the United States. As a leading provider of cloud computing, U.S. companies stand to benefit tremendously from the large expected growth in cloud computing worldwide. Not surprisingly, other countries are aggressively challenging U.S. leadership in this market. While fair competition is legitimate, Some countries are using unfair policies to intentionally disadvantage foreign competitors and grow their domestic cloud computing industry. The rise of cloud mercantilism is an emerging threat to the global trade in information technology. Some countries are using data security and data privacy regulations to create geographic restrictions on where cloud computing service providers can store and process data. Other countries have policies that explicitly require cloud computing service providers to operate data centers domestically. These requirements have the effect of making cloud computing less efficient, since decisions about where to locate data centers or how to operate them must be made on political mandates rather than technical or economic factors. Localization requirements also serve as a form of protectionism for domestic cloud computing providers, since it may not be economically viable for a foreign competitor to build a domestic data center. Examples of this type of behavior can be found in many countries. For example, Greece, Vietnam, and Brunei have all passed laws which require data generated within the country to be stored on servers within those countries. Both the Norwegian and the Danish data protection authorities have issued rulings to prevent the use of certain cloud computing services when those servers were not located domestically. The government in Kazakhstan issued an order to require that all .kz domain names operate on servers located within the country. China, Russia, Venezuela, and Nigeria have all passed localization requirements, ostensibly to protect national security and payment processing. And similar types of laws are pending in other countries, including Indonesia, Malaysia, and Ukraine. Strong U.S. leadership is necessary to combat the unfair trade practices that other nations are using to block foreign competitors in the rapidly growing cloud computing industry. First, the U.S. government should clearly and definitively state its opposition to local data center requirements and highlight instances of noncompliance by foreign governments. For example, this type of behavior could be highlighted by the USTR in a Special 301 report. Second, the U.S. government should affirm its intention to refrain from imposing its own local data center requirements. These policies may be tempting, but they diminish the capacity of the United States to hold other countries accountable for similar forms of protectionism. The long-term goals of the U.S. government should be to work towards eliminating geographic restrictions on cross-border flows of data. U.S.-based cloud computing service providers have the most to lose if these type of barriers become widespread. After all, the domestic market for cloud services is much smaller than the global market. Thank you, and I look forward to your questions.
The chair is going to diverge from regular order because the gentleman from North Carolina has some other obligations, and we want to recognize him first to ask his questions. So we'll turn now to him.
Thank you, Mr. Chairman, and I thank you for accommodating my schedule. Unfortunately, I've got something that started and I need to be at immediately, but I didn't want to miss the testimony or miss the opportunity to ask questions. All of the testimony was very interesting and raises some very, very interesting issues. Seems to be unanimity on the question of cloud neutrality. I take it everybody is in agreement on that. That means, I take it, that the same rules that apply to things outside the cloud should apply to things inside the cloud. Would that be a fair definition of cloud neutrality?
I do think that's a fair definition.
Okay. But then you raised some interesting questions about which in essence brings us back to the same issues, a lot of the same issues that we've been dealing with outside the cloud. Protection of personal security, personal information for consumers, an issue outside the cloud. Protection against trolls suing each other, although the owners of patents are suing each other regularly, which is a big problem. Protection against piracy, which Mr. Holloman raised in the context of the cloud, I presume to protect protect programs and what have you from, but that's not unique to programs. Piracy is a problem. And I don't want this to devolve into another question of how we protect ourselves against piracy, but it does raise the question of whether, in light of the failure of our committee to be able to deal with that effectively, and the withdrawal of the proposal that was on the table, whether any affirmative steps are being made by the industry to address piracy, either in the cloud or outside the cloud. If you're going to have a neutral cloud neutrality, and you've got problems outside the cloud, then we've got to commit ourselves to working on the problems outside the cloud so that when we adopt the principle of cloud neutrality, those same principles will protect us inside the cloud. So is anybody making any progress in the sector? You all were obviously all involved in this SOPA thing on one side or the other. I don't want to, we're not here to recreate that debate today. I just want to see whether you all think any progress is being made, because if we're going to transport that issue to the cloud, we're going to have cloud neutrality. I think we got to deal with it. So, Mr. Holloman.
Mr. Watt, thank you for the observation and the question. The point which I wanted to make clearly about piracy in the cloud is there was a common myth, and candidly, I probably believe this myth as recently as 2 years ago, that software piracy goes away when software is used in a cloud context, and that where you actually have piracy is with the physical media, but that when you shift it to the cloud, you don't have the problem of piracy. And in fact, what we found is that the piracy evolves. I do think you will have less software piracy in a cloud context, but we identified at least 4 ways in which it can occur, one of which will occur when unscrupulous hosters, fortunately there are none that I know of at this point, but they may be ones outside elsewhere or whole.
All right, you're identifying a set of problems in the cloud that are unique to the cloud, and I want to deal with that, but that was not really my question. Okay. And I'm running out of time.
I think your question, if I understand your question correctly, it was saying that some of the problems that we currently see are simply going to be transferred into an environment in the cloud. So what we need is effective tools to deal with those, and that's going to require self-help by industry, and that's also going to require appropriate use of law enforcement resources when the piracy can be identified, whether it's in the cloud or outside the cloud.
Well, my question was whether we're making any progress toward solving this problem outside the cloud or in the cloud. I guess that's the question. That's the baseline question I'm asking.
I think we are making some progress outside the cloud where piracy is bigger in reducing levels of piracy. I think we've seen some good cases the Justice Department has brought that's been helpful. We bring about 10,000 cases a year. We're seeing piracy rates for software come down, but what we have to make sure is that the tools that we need can continue to work in a cloud-based environment.
Can I just open up one other area of inquiry? I know my time.
Without objection, the gentleman is recognized for an additional minute.
My time has expired because it seems to me that this debate about whether we protect ourselves against other countries putting up barriers that allow hosting only in their countries is similar to this question of whether we put we don't prohibit call centers from going offshore. The question is, how do we protect ourselves? How do we protect our own consumers' information without those kinds of barriers in our own country, and if we put them up in our own country, doesn't that incentivize other countries to put them up there? Same thing with national security concerns. If we are allowing our national security apparatus access to information in the clouds, wouldn't it be a legitimate concern for other countries to be concerned about the extent to which our national security apparatus would have access to their information in the cloud? Perhaps I'm raising, I'm not looking for answers necessarily to all of these questions, but it just seems to me from my simplistic mind that if we're setting up a set of neutral standards internationally and we're trying to get people to play by those rules, we have to anticipate that we've got our own set of issues we must deal with domestically before we can start fussing at everybody else internationally. Am I off on the wrong cloud here, or do you all agree with what I'm saying?
I'll start by saying, look, I think we need to do both simultaneously. I mean, there are some gaps in U.S. law that we think need to be resolved, like the need for ECPA reform that would ensure some greater levels of privacy for data that's stored in the cloud, and that would be important signal for other countries. And secondly, we have to be aggressive in making sure, as one of my colleagues said, that we don't put rules in place that require all data on all U.S. citizens in all contexts to be held in the U.S. We don't require that now. There's some people who would like to do that, but if we did it, it would be a signal to every other country that they could do the same. So we have to live by that openness, but know that there are appropriate privacy and security regimes that will protect appropriate levels of data for U.S. citizens wherever that's hosted.
Mr. Chairman, I appreciate you accommodating my schedule. I wish I could stay for another round of questions because really I came with the intention of talking more about competition in the cloud, and I didn't ask a single question about competition. So
if you would submit your questions for the record, we'd be happy to submit them to all the witnesses and ask them to respond. And we appreciate the gentleman's participation. The chair now recognizes the gentleman from Texas, Chairman Smith.
Thank you, Mr. Chairman. I'd like to try to see if I can squeeze in questions on the subjects of patent trolls, privacy, security, and foreign countries. Let me direct my first question to Mr. Freeman. You and I have talked about this subject, and I've talked with two others within Rackspace on the problem of patent trolls and the frivolous lawsuits they file and the cost to the company and to other companies across America. I think we're aware of the problem, though if you want to discuss it in greater detail, you're welcome to. But what do you think are some of the solutions to this almost exponential growth in lawsuits, litigation derived from these patent trolls?
Thank you, Congressman. I think two key mechanisms are to limit the incentives that patent trolls have to bring actions for profit without practicing their invention or practicing the patent. One approach along those lines is to limit the potential reward from litigation to the actual value of the license or that the troll or acquiring entity paid for a patent if it's not also practicing the patent. That's a case where the patent troll is essentially not being harmed by the practice of the invention by another entity. Yeah. So it should not essentially get an ill-begotten gain simply as a result of holding on to a patent in an attempt to block innovation. Another mechanism is to shift towards a framework where legal costs and responsibilities are borne more equitably between the two parties. A loser pays approach has been floated, and there's some interesting potential reforms along those lines. They can make it so that a patent troll has a lot, or a litigator has a lot on the line when they file a claim for an infringement action.
Okay, good suggestions. In regard to the first, I think we would have to probably be careful so that we wouldn't apply such a reform too broadly. You can't say it's illegal for someone to hold a patent just because they're not using it. But I understand the thrust of your reform, and I agree with that. Mr. Holliman, on the subject of privacy, what are some of the privacy issues involved with cloud computing that we need to be aware of? And you just started getting into that a little bit, I think, in response to the question from Mr. Watt.
Right. On the issue of privacy or piracy?
Privacy.
Privacy.
Yeah.
Well, look, I think on the issue of privacy, one of the single biggest issues is going to be how we work in the context of the European Union, which is moving to adopt a data privacy regulation that will be, unlike a directive, this will be mandatory across all 27 member states. There's sort of an 18 to 24-month process in which that's happening, and that's going to require a regular dialogue with the U.S. government, both administration and U.S. government members of Congress, because at the end of the day, we have to have a regime that preserves the safe harbor, that provisions that currently have been negotiated between the U.S. and the EU so that data can be exchanged appropriately across borders. And that we also have to ensure that the Europeans do not adopt a privacy regime that's so restrictive that will have a de facto effect of blocking access by U.S. companies.
And as you say, we've seen some signs of that already, I think.
Absolutely.
Thank you. Mr. Chinook, I want to ask you about security issues involved with cloud computing. You touched on them a minute ago, but can you elaborate?
Yes, thank you for your question, Chairman Smith. Security in the cloud
Is your mic on?
Yes,
Thank you.
I will do that. Thank you for your question, Chairman Smith. Security in the cloud is not dissimilar to how security is handled in other forms of technology. You could imagine a cloud with very strong security protections built into the system, lots of surveillance of the internet traffic coming in and out of the cloud, immediate warnings to the operators of the system that then go out to the users of the cloud if there's an incident. Similarly, you could imagine those same kinds of protections being built into a well-constructed system that's a more traditional system, let's say a client-server system or another type of computing system. So security issues in the cloud are, in some ways, can be built very well or not. And the key is to incentivize, and for companies like ourselves that are here with you today, to understand how to build security into solutions that we develop for the cloud from the beginning so that customers of ours, consumers, businesses, and governments have confidence that the solutions that we provide and the solutions that are discussed in the context of government-to-government discussions are secure and private. The other point I'd make, just reiterating what was in the testimony, is that the cloud itself can provide for a much more rapid response if there is a security incident that comes in. If you're in a traditional environment with lots of different servers in different places and different people worrying about those, and a computer security incident occurs and a patch to fix the incident is delivered, it's often delivered essentially manually from place to place and person to person. With a cloud, you can deliver that patch automatically, instantaneously, and the problem is rectified immediately.
Okay. Thank you, Mr. Chinook. I'm out of time. Mr. Castro, I just want to thank you for answering my question a minute ago in your opening statement about the threat of foreign countries and what our government should do. You were very specific. I hope the administration will listen. Thank you, Mr. Chairman.
I thank the gentleman. The gentleman from New York, Mr. Nadler, is recognized for 5 minutes.
I thank the gentleman. Mr. Castro, a key guiding principle articulated by several company witnesses at one of our prior hearings held in September 2010 when I was chairman of the Constitution Subcommittee was the desire for technology neutral or cloud neutral, as it's been described today, standards for government access to communications under the Electronic Communications Privacy Act, ECPA. This would mean that with regard to government access to content communications stored in the cloud, communications stored in the cloud would be treated the same as communications stored locally by a customer. If a primary goal for ESPA reform is establishing clear and consistent standards, it does seem that this would be essential. Do you agree?
I do agree.
Anybody else agree or disagree on that? Everybody agrees that we should have the same standards for government access to material stored in the cloud as for government access stored on your laptop. And Mr. Holliman and Mr. Chenook, the principle we are discussing, that of cloud or technology neutrality, is a core principle of the Digital Due Process Coalition. DDP takes the position that government access to content communication should require a search warrant issued based on a showing of probable cause, regardless of the age of the communications, the means or status of their storage, or the provider's access to or use of the communications in its normal business operations." Close quote. This technology-neutral standard adopts the current standard for communications stored by an individual locally for the communications stored in the cloud. IBM and BSA are members of the Digital Due Process Coalition, so I presume your companies would support a bill adopting this standard. Would you agree with that, or you comment on it? Mr. Holliman first.
BSA is a member of the Digital Due Process Coalition, and we support their recommendations.
And IBM is a member of the Digital Due Process Coalition and support moving forward, yes.
So you would agree that we should have the standard should be a due process standard, a search warrant based on a showing of probable cause, regardless of age. We have in ECPA now these different standards based on whether it's longer than 180 days or less than 180 days, based on assumptions 25 years ago that if you had it on your computer or on somebody else's computer for more than 180 days, obviously you didn't care about it. You didn't care about your privacy. Does everybody agree that that logic is no longer the case? Everybody seems to agree?
Yes.
Mr. Heller, I agree with that logic, and again, we're part of that coalition and support those recommendations. I'd actually like to follow up with some additional detail for the record for your question.
Well, I would join Mr. Holliman in following up.
I thank you. I yield back.
I thank the gentleman. The gentleman from Pennsylvania, Mr. Marino, is recognized for 5 minutes.
Thank you, Chairman. Good afternoon, gentlemen. Thank you for being here. As a former prosecutor, I believe that for every action, there is an equal and opposite reaction. So with that said, we in America, we're very good at developing technology, the best in the world, I think. But nevertheless, we fall short worldwide of anticipating the downside of our advancements in our technology. And in pursuant to our topic today, the clouding issue, I'm going to ask each of you to take a moment and perhaps predict what you see the downside of the technology that we're achieving today concerning clouding. Do you understand my question? Mr. Holliman?
Look, I think the biggest downside I see is that there are going to be a lot of changes in the economy that result as you move to using this new technology, which means the nature of some jobs will change. The nature of how information is stored has changed. But as I began with the IDC report, there is also a huge value add to the economy, as much as $1 trillion in new growth, not just in technology, but across all sectors because of cloud-enabled innovation.
Okay. Mr. Freeman, do you have a comment?
I think I echo those thoughts. There's going to be an economically disruptive effect as the amount of data that's available and information about individuals' consumption behaviors is magnified exponentially. If there's not an alignment of the legal principles and legal system applicable to types of data, regardless of whether they're stored in the cloud or locally, I think that's going to pose a big challenge and potentially be disruptive to continued cloud innovation.
Thank you. Mr. Chinook?
Thank you, Congressman Marino, for your question. I think 2 points. One, if not implemented well, as with any technology, cloud can increase issues involved in how a technology is placed in a work location or used by a user. So the concern would be to address cloud's implementation and make sure that it is done in a manner that addresses some of the issues that we've discussed here today earlier with regard to location mandates and open standards, to make sure that those types of policy choices are built into the implementation. Without that, you could get some unintended effects. And also misperceptions. Some of us have talked this morning about certain beliefs about the cloud that aren't necessarily true in fact, but color how people come to it and color the uptake in terms of use of the cloud. And so taking a fact-based view, I think, is very important.
Thank you. Mr. Castro, do you have a thought?
Yes, I think cloud computing technology it's disruptive for businesses and organizations and government in very positive ways, but It's also, of course, there's a duality to technology, and it can be used for negative purposes as well. So just as we see legal businesses becoming more productive and doing more with this technology, we can also see that taken up by illegal activity to be more productive, and obviously that's a very bad thing.
Good segue into my next question concerning the illegality of it and the potential of those outside, it shouldn't be in a particular area, garnering information, penetrating the system. How about our security end of the thing? Anyone?
I think you need in a cloud context, you need to look at kind of the access controls and how it's secured. I mean, the cloud, if configured properly, can be a much more secure environment than the highly distributed environment we have today, where people leave laptops or they leave their thumb drive. And so if done properly, the cloud can be a net positive.
Let's take it a step further, and I'm going to use an example. Years ago, in law enforcement, we developed a basic walkie-talkie where law enforcement could communicate with one another. But then quickly, there was developed a scanner where the criminals could hear that we were coming after them. So how do we prevent that? Has that been taken into consideration at this point? I know we're anxious to put this all together, but are we thinking of the ramifications and the technology that can really counter what we intend to do?
So, Congressman Marino, there are technical protections that can be built into data in transit that can be established and assigned to the cloud, and in terms of understanding how information is moving and whether there is interception of that information while it's moving, and can very quickly spot when somebody's trying to penetrate a system or penetrate a set of information resources that are moving along, and then quickly identify how to resolve that situation. And continuing to build those technologies in and designing the system properly from the front will help to address those types of risks.
And Mr. Castro, I'm going to flip a question to you. I'm running short of time here. How many entities within, when I send my email to whoever's receiving it, are going to have access to that information within that cloud?
In theory, you could have just one. You could have just the one actual provider, depending on how the cloud computing environment is set up. Ideally, you have it virtualized in a way that the data is actually segmented in ways that other providers that might be offering services wouldn't actually have access to your specific data.
I see my time's run out. Thank you, gentlemen. My daughter's going to be proud of me because I was talking about the cloud system today. Thank you. Thank you, Chairman.
Does she think most days you have your head in the clouds, or is it like my teenagers did when they were that age? The chair is pleased to recognize the gentlewoman from California, Ms. Lofgren, for 5 minutes.
Thank you, Mr. Chairman. My apologies for being late. I had a competing meeting. But I do think that this is a very important discussion. I understand Mr. Nadler raised the issue that I've also been working on of a need to update ECPA for our current technology times. It's been a long time, and there's certainly privacy issues that need to be addressed, and certainly some of the assumptions that Americans have about the privacy afforded their digital data is not, in fact, adhered to under the legal standards. And so that's something that I hope to help address as time goes on. I'm wondering in terms of as we deploy throughout the world, whether there are issues that we also need to address on standard setting for interoperability and portability of data when it comes to cloud computing. Something I've not heard discussed at all, and yet I think it's pretty obviously something that needs to at least be attended to. Is that a miss? Am I misadvised to be concerned about that?
I think that's very correct. I think there's two key types of portability that have to be considered. The portability of user data. You can rapidly see adverse effects if cloud data or user data is stored within a given provider and users or businesses are essentially held hostage and unable to
That's right.
extract that data later. The other thing is the portability of applications, the services that essentially are the cloud. If a government agency or a business is too reliant on a single provider's proprietary infrastructure, it may find itself unable to migrate out to either another provider in the case of a service issue, or be left without an alternative solution in the case of a service failure.
Mm-hmm. I'm interested as well. I think some of the security issues have been dealt with, but I think there's an overlap between, maybe for lack of a better word, security issues and interoperability. And I wanted to raise the issue of, I'll use the U.S. as an example. We recently took an action, we as the United States government, against a site alleged to be a big pirate site, Mega Upload. But in a way, that's also cloud computing. I mean, it's not what we think of in the business world, but that's what it is. Have you addressed the issue of governments aggressively enforcing property rights when it comes to cloud computing that then disadvantages other users? We've heard, for example, that there are why somebody would store their baby pictures on Mega Upload. I don't know, but apparently some people did, and now their baby pictures are going to be toast. Have we addressed that issue as a group that thinks about it, how we can protect innocent users when there are enforcement actions?
Ms. Lofgren, I'm certainly familiar with the Mega Upload case, and I know that there are some pending proceedings, both at Justice and in the courts, of which I'm not privy to.
Right. I just use that as an example. You don't have to talk about that case.
Look, I think one of the questions is, given the scope of some of what I would refer to as just storage facilities, and how to ensure that you have protection for the legitimate data that's stored, recognizing that you still need tools to be able to deal with the illegitimate data that may be stored, or the hosting entity. And I think it's going to take a balance of laws. What's important, though, is that you still have to have tools, both civil and criminal, that allow you to take actions.
Well, I'm not arguing that case, but nobody seems to feel any responsibility towards people who are completely innocent here. And there's no standards, there seems to be no interest or obligation to innocent bystanders to this action. I'm wondering if there isn't something that we ought to do to address that issue.
I can't suggest an answer to that. I think that's a legitimate it's a legitimate question you're answering. I mean, we had, as BSA, been engaged in a lot of notice and takedown activity with Mega Upload, and there was certainly some illegal software that was part of that.
Sure.
And there's now been, we both independently and obviously through Justice have had some recourse, but I can't go beyond that to talk about.
Well, let's just use it as an example, not that.
Without objection, the gentlewoman is recognized for an additional minute.
Thank you, Mr. Chairman. If any of the witnesses have a suggestion on whether we shouldn't have some standards so that innocent bystanders, if you will, have some recourse and rights, I would be maybe off calendar eager to hear them.
I'd like to speak to that, if I may, Congresswoman. I think the key is an alignment of existing privacy and criminal standards with regards to search and access, regardless of the location or the nature of how data is stored. You highlighted ECPA earlier. An email is treated differently when I print it out and put it in my desk than it is when it's on my computer, than it is when it's on Gmail server. That alignment, along with a bit of international consistency, I think will solve the problem for both businesses and consumers. Mega Upload is a case that, for example, highlights the use of mutual legal assistance treaties to create a coherent and enforceable regime. But if those standards aren't consistent with regards to data type, regardless of technology, and if they're not consistent internationally, there'll be a lack of transparency and a perceived lack of protection for users' data.
The time of the gentleman has expired. And the chair will recognize himself for questions. Mr. Holliman and Ms. Freeman, what are some of the more egregious market access issues that BSA or Rackspace or other businesses have found foreign countries engaging in against American cloud computing companies in the European Union or in countries like Canada, Australia, India, Japan, China? As I've prepared this question, it seems to have gotten longer. I'll start with you, Mr. Holliman.
Mr. Chairman, it is unfortunately an increasingly long list, as we pointed out in our report. I'll give you two countries at opposite ends of the spectrum. China has a requirement that you must have a joint venture with a Chinese entity to provide a cloud service in China, and there's a condition of providing source code in conjunction with that, and China is no longer allowing any joint ventures, and of course companies are rightly resisting any source code disclosure. So effectively you have a great wall that's been erected and continuing to be erected that's going to shut out companies in the China market. On the opposite end of the spectrum, you have the concerns I see happening in Germany, where German government officials are talking about the fact that all German data should be stored in Germany, both high sensitive and low sensitive and medium sensitive data, not only for the German government, for German citizens. And then you have a marketing campaign by Deutsche Telekom, which is effectively a third owned by the German government, that's invoking the Patriot Act and citing the Patriot Act as a reason why customers should use Deutsche Telekom's hosting services over U.S. providers. And so I think those are two ends of the spectrum, and we need to address those problems in both countries, and they're just an example of what we see elsewhere.
Does Deutsche Telekom still own T-Mobile? Is that their relationship there?
My understanding is that they still do, but I'm not the expert on that.
So following up on that very distressing point, having worked as hard as I have on the Patriot Act, what are some of the misconceptions that they are spreading about the Patriot Act or data privacy policies in the United States in general that would help them steer business to German companies or other countries that may be doing the same thing?
I'll tell you, at Rackspace, we commonly see almost occasionally absurd positioning of what the Patriot Act permits, to the extent that it allows almost any U.S. government agency to, without notice or warrant, access any private data that's on a server contained within the United States. That sort of
well, that's totally false.
That sort of fear, uncertainty, and doubt, I think, informed Canada's FOIPA law, which is a good example of a protectionist measure that excluded U.S. participation in a marketplace. Canada passed a patient privacy bill that prohibited the storage of any patient health information on any server located in the United States based on this fear and uncertainty. Now, I think it was more of a protectionist measure that leveraged that type of fear. But our great concern is that we see the same types of behavior, same types of positioning being touted in marketing campaigns, such as in Germany and the rest of Europe.
So, what do you do to counter that? Do you have a Rackspace Germany that's a separate entity and with your
even
cloud
having
computing capabilities there, or what do you do?
Thank you, Chairman. Even having a subsidiary entity these days is being targeted. Essentially, there's an approach that anyone who has either a server in the United States or is a subsidiary or joint venture with a U.S. company is becoming suspect. Again, I think these are really pretenses for protectionist pressures, and that they're not based on legitimate understanding of the legal principles. I think the best way to deal with it is through education and the establishment of international standards and clear statements from the U.S. government about how the Patriot Act works and how it's utilized and implemented. I think we all are sort of aware that foreign countries all have access in certain circumstances to data for servers that are located on their soil.
I would argue most countries have far greater access to that data in their countries without the Bill of Rights that the United States Constitution provides for protection of U.S. citizens that would extend to anybody storing their data in the United States. So what do you suspect we should do with regard to this in the sense that it is a trade issue, it is a protectionist policy? Have any of you approached the U.S. Trade Representative to
Chairman,
press this issue?
I'll give you a couple answers. I mean, one is that the State Department has actually been very aggressive in raising this with other countries. Ambassador Verveer leading that effort. There's a new Mythbusters document that State and Justice are working on to try to dispel the myths about the Patriot Act and unfair, and dispel the myth that somehow the U.S. has powers here that other countries have. And I think there has to be a bilateral, aggressive negotiation. And I also think that you see through USTR on efforts like the Trans-Pacific Partnership and building new trade agreements that deal with issues around cross-border data transfers that are related to, but an important complement to dispelling these myths about the Patriot Act.
Mr. Chinock, as more data moves to the cloud, where do you see the future of data analytics? What are some of the innovations that we can expect in this new field of technology? Put the microphone on again.
Analytics runs on a parallel track, Mr. Chairman, if you will, with the cloud. The cloud enables companies of all kinds and governments to understand information regardless of where it sits. Through the cloud, you can use technology to get to information more effectively and efficiently and at less cost. So it enables the type of analytics that can be done to really make decisions very quickly and rapidly based on data regardless of where it sits over an open cloud without having to establish point-to-point agreements or computer interface exchanges that might take time and increase cost to achieve the same level of the data coming together to make an analytical decision. So the two are related and mutually reinforcing.
Thank you. Well, those are the questions that I have. Since the buzzer for the votes haven't gone off yet, I'll ask the gentleman from Pennsylvania or the gentlewoman from California if they have an additional question they'd like to ask the panel of experts before we dismiss them.
Mr.
Gentlewoman from California.
Thank you for that opportunity. There was some testimony on abusive patent litigation, and it's something I'm concerned about, but I'm not sure we've got the energy to wade back into patent reform. But I'm wondering if we could get some suggestions on how the Patent Office itself might make that situation a better one.
Thank you, Congresswoman. I think it's difficult to approach it with the current regulatory authority of the Patent Office itself. I'm reluctant to tell you that I have all the solutions to the problem because it's really based on behavior.
Join the club.
Yeah, it's really based on the behavior of a set of entities who are exploiting a system that works well in many cases. And there's no need to throw out the baby with the bathwater, so to speak, but I think responsive action is necessary. One area is particularly in regards to the development and increasing use of open source cloud software. The patent system does not work particularly well when it comes to collaborative open source projects because it really did envision more of a focused reward and innovation generating system.
Well, we did have just recently some further discussion on standard setting in the patent system and how we might work with that. So I'm sorry I was unable to get here for all the testimony, but I do think that when you look at what, as the chairman has said, certain countries are doing in terms of using tools to block market access, sometimes with legitimate concerns, honestly, about the lack of standards in American law. I mean, EPCA is one of them. We have a lot of work to do in this area, and I'm glad that we had this hearing, Mr. Chairman, and I think we will be working diligently in the coming months to address some of these issues. And I yield back.
I thank the gentlewoman. The gentleman from Pennsylvania does not appear to have any additional questions, so we will thank our witnesses for their excellent testimony today. And without objection, all members will have 5 legislative days to submit to the chair additional written questions for the witnesses, which we will forward and ask the witnesses to respond to as promptly as they can so that their answers may be made a part of the record. Without objection, all members will have 5 legislative days to submit any additional materials for inclusion in the record. And with that, I again thank our witnesses, and the hearing is adjourned.